Good morning, and thank you for joining our webinar, Are You a Target for a Department of Labor Audit? Our agenda today will include the fundamentals of health and welfare plan compliance, how to get audited by the Department of Labor, voluntary benefit plan safe harbors, and why are they important, and how to attain and maintain plan compliance. I'm Robert DePriest, and I'm joined this morning by David Hall, Chief Marketing Officer of Hall Benefits Law.
Good morning, Robert. It's great to be here. I'm excited about the information we'll be sharing today. I do want to take just a moment to let everyone know about our handouts. In the GoToWebinar control panel, there's a section called Handouts. The 4 documents there are available for immediate free download. There are 2 items from Hall Benefits Law, along with 2 items from Select Choice Benefits. Robert and I hope you will find these resources useful. Robert?
And I've had the pleasure over the last several years to get to know both Ann Tyler Hall and David Hall to better understand how both our firms can help employers meet their fiduciary responsibilities as plan sponsors. Our webinar today is intended to provide a general overview in terms of basic ERISA requirements relating to your group-sponsored medical plan, as well as your group-sponsored voluntary benefits plan. And we will share some real-life scenarios based on both our firms' experiences. Now, our discussion today is intended to be informative and not intended to be an exhaustive representation, and certainly not specific to a particular plan sponsor. In the interest of your time, we're not set up to take live questions. However, we encourage you to send in your questions, and we will respond to each question presented. Now, before we get into the agenda, I thought it might be helpful for everyone to learn a little bit more about both our organizations. And David, I'll defer to you.
Thanks so much, Robert. And just as a quick piggyback onto the comment about questions, there is a question panel in your GoToWebinar control panel. And if you enter your question there, it will be logged, and we will be able to view that question after the webinar, and we promise to get back to you individually. So, Hall Benefits Law. Thank you guys for being here. My name is David Hall. I'm the Chief Marketing Officer and former firm manager at Hall Benefits Law. We're the nation's fastest growing solo-owned ERISA law firm. We're a boutique law firm headquartered in Atlanta, serving clients in 30 states. Our signature is our proactive approach to employee benefits legal compliance. And our team regularly writes, speaks, and publishes in an effort to educate the plan sponsor community about the importance of fiduciary compliance and the way in which benefit plans form the foundation of thriving businesses. That attitude is one of the reasons that I'm excited to partner with Robert today. We believe that benefit service providers, from brokers to third-party administrators to consultants to ERISA attorneys, are all part of an employee benefits ecosystem. And plan sponsors are best off when they're working with partners who understand their unique role in that ecosystem, all to the benefit of the plan sponsor. Hall Benefits Law's role in that ecosystem is to help create and maintain compliant employee benefits plans. While we will be talking primarily about health and welfare plans today, I do want to mention that our team is also adept at working with plan sponsors on retirement plans, executive compensation, ACA compliance. In addition, we have resources on the HR and employment law side that are proving to be critical to plan sponsors during the COVID-19 pandemic. I hope you will not hesitate to reach out to me directly for questions about any of those particular areas of the law. And I can connect you to someone on our team who's qualified to answer your questions. You will see today that we're working with folks like Select Choice Benefits to deliver helpful tools for employers, and we can't wait to share one of those tools with you later today. With that, I'm going to turn things back over to Robert.
Thanks, David. Well, Select Choice Benefits is an employee benefit human resource capital firm providing guidance to our clients in 3 specific areas: group medical plans, group voluntary plans, and their 401k retirement programs. Our philosophy is taking the complexity out of your benefit decisions, and we aim to do this, not just during your renewal or open enrollment, but all year round. And we view ourselves as an extension of our clients' human resources department. We do this by focusing on a big picture strategy of managing their overall healthcare budget. As the health and welfare practice lead here, I've had the great opportunity to be in this field for over 30 years. I was raised in Michigan. I started my career working for Blue Cross Blue Shield in Toledo, Ohio, and later with Anthem Blue Cross running the Northern Sales region for a combined 18 years. I like to tell people that I cut my teeth working with Taft-Hartley employers. And for those of you familiar with this space, the multi-employer groups, union groups, having worked with organizations like the AFL-CIO, the United Auto Workers, and the Teamsters Local 20. There I learned the foundational elements of plan design, structure, working with the financing of a plan, and mandatory no loss, no gain provisions that were alive and well at the time. And this experience served me well, working with small to large employers of diverse industries and geographies throughout my career, including some Fortune 500 firms. So we at Select Choice Benefits are fully engaged with our clients in terms of assisting them with the procurement, the design, the financing, the compliance, and the enrollments of their plans. Many things in terms of plan designs, services covered, or financing a healthcare plan have not changed dramatically since 1985, interestingly enough. However, regulatory compliance, including the ACA or the Affordable Care Act and ERISA regulations, continues to be burdensome for plan sponsors. Now, ACA is for another subject. However, I'd be remiss if I didn't mention how it radically changes the regulatory landscape. And thanks to the Affordable Care Act, health and welfare benefits are on the IRS and Department of Labor's radar like never before. And David will expound on that as well. But our focus today are the ERISA rules for employers who have a health and welfare plan. Many of you already know ERISA stands for the Employee Retirement Income Security Act of 1974. It applies to all private employers except those who qualify for an exemption. It provides uniformity and protection to employees. It requires plans to provide participants with plan information, including plan features, reporting, funding, fiduciary responsibility, the identification of those who manage and control their assets. Regulates both employee pension benefit plans as well as employee welfare benefit plans. ERISA is administered by three bodies: the Department of Labor under the Employee Benefits Security Administration, the EBSA, the Treasury Department under the IRS, who doles out the penalties, and the Pension Benefit Guarantee Corporation that focuses strictly on pensions. What employers are exempt from ERISA? Well, there are four types. Employers administering governmental plans, whether they be federal, state, or local. Church plans. Employers that have compliance plans. These are employers that maintain certain benefit plans for specific purpose of complying with federal or state statutes, like workers' comp or unemployment comp. And then foreign plans, those plans that are essentially domiciled and maintained outside of the U.S. So let's get into our first topic of the day. That is the fundamentals of health and welfare plan compliance. Well, let's start with ERISA Section 3.1. The term employee welfare plan or welfare plan means any plan, fund, or program which was established or maintained by an employer or by an employee organization, or by both, to the extent that such a plan, fund, or program was established or maintained for the purpose of providing its participants, the employees, and beneficiaries, their dependents, through the purchase of insurance or otherwise. It goes on to define medical, surgical, or hospital care benefits, or benefits in the event of sickness, accident, disability, death, unemployment, vacation benefits, and it lists others. What it excludes are pensions or retirement or death and insurance to provide such pensions. Let's talk about ERISA requires a plan document. Now, this becomes a misnomer with a lot of the clients that we meet with. Many of them think that the insurance documents suffice, and it doesn't. ERISA provides that every employee benefit plan shall be established and maintained pursuant to a written document. And such instrument shall provide one or more named fiduciaries who jointly or severally have the authority to control and manage the operation of the plan. ERISA requires a summary plan description. Summary plan description of any employee benefit plan shall be furnished to the participants and beneficiaries. The SPD shall be written in a manner calculated to be understood by the average plan participant, must be sufficiently accurate to give them the information to understand their rights and obligations under the plan. Now again, as I'm talking to a lot of customers or clients out there, they seem to think that the certificate of coverage provided by their insurance carrier will suffice. It does not. And I know there's a lot of terms being thrown out in the healthcare marketplace. Certificate of coverage, a COC, used to be called a certificate of insurance. You have their SPD, you have an SBC, the summary of benefits and coverage. Let's be specific. A summary plan description is a templated document that's required by ERISA. Insurance documents don't meet these requirements, as I said, because insurance documents are issued by the employer, or not issued by the employer, they're issued by the plan, or the plan, they're issued by the carrier, I'm sorry. Insurance documents have no protection for the employer or their internal plan fiduciaries. And insurance documents do not contain the required information and notices, including the employer identification number, eligibility and termination provisions, the agent for service or of process, or the fiduciary identification, and there's more. Why do we have the documentation? Well, under ERISA Section 402 and 102, it's law. And under ERISA Section 502 and 504, the Department of Labor enforces it through the Employee Benefits Security Administration. And under ERISA 502, the participants and their attorneys have the right to request it. And there are penalties. The Department of Labor can impose a penalty of up to $159 per day, up to a maximum of $1,594 per request. The participants, as well as the participants' attorneys, can request it, and there are penalties up to $110 per day. And I think it's fair to say that when an attorney gets involved, it can be more problematic for the plan sponsor. David?
Well, Robert, I think that's an interesting point you make, and I would simply qualify it by saying that it's absolutely problematic when ERISA counsel becomes involved at the wrong stage of the process. And I think this is a good segue into our next section of the presentation today, how to get audited by the DOL. Now, let me first say that we believe every company should have access to ERISA counsel, and that plans of a certain size need input from counsel, and that the highest and best use of our team's time is helping plan sponsors constantly move toward compliance. Now, back to the slide, we got a little bit tricky with our wording here, did Robert and I hope you in the audience won't feel like we pulled a bait and switch, as it certainly wasn't our intent. But we understand that a DOL or IRS audit of benefits plans is many plan sponsors' biggest fear, so it's a real attention grabber. In truth, the very best way to get audited by the DOL, or the IRS for that matter, is to proactively avoid an audit. When proactive risk mitigation has occurred, the likelihood of an auditor spending much time with a plan sponsor who has actively engaged ERISA counsel and others in the benefits ecosystem to create compliant plans is very small. I'm going to give a classic example of how plaintiffs' attorneys go after plan sponsors, and also show you a couple of items our own team has been working on recently that will hopefully shed some light on the importance of being proactive. Of the three matters I cite, only one has to do with the DOL. Again, the fact that we're talking about being audited by the DOL is an attention grabber. This is not a DOL issue, guys. It's a plan sponsor proactivity issue. We urge you to control the things that you can control, and you cannot control the DOL. You can control your level of plan compliance. So first, let's look at some quick tips relating to proactivity relative to an employee benefits legal compliance paradigm, specifically health and welfare plans. So here are some tips. Number one, as I've mentioned previously, be proactive. Work with ERISA counsel regularly. So many of our clients come to us when they have been subject to an ACA penalty, or they've received an audit letter from the DOL, or the IRS is banging on their door, or they have a plan sponsor, a participant complaint. Those plan sponsors who are regularly working with counsel to maintain compliance do not have the same level of issues as those who do not. Third, notify ERISA counsel of any changes to your benefit plans, no matter how seemingly insignificant. Small changes can have huge penalties if you do not maintain and run the plan according to the plan document. Get real about ACA, HIPAA, and COBRA compliance. All of these three things fall under ERISA, and there are steep penalties. We'll talk about some of these penalties relative to some of the other pieces of ERISA shortly. Have a wrap plan document in place if you have multiple health and welfare plans. More to come on that later. And finally, guys, doing the dirty work of submitting forms 5500, non-discrimination testing, all the things that you have to do to maintain plan compliance. Don't rely on a payroll provider to do that. You need a professional who has you've seen the mistakes that the payroll providers are making and corrected it hundreds of times to do that first. Our team can file forms 5500 on behalf of our clients, and they're not coming back with penalties or proposed penalties from the IRS because the paperwork is done right the first time. All right, let's look at some examples. So and forgive me, Robert, I'm going to backtrack a few slides here. When I was introducing myself, I completely forgot to share this slide, and I'm sharing it now because we're going to be giving you an example from this book, A Plan Sponsor's Guide to Employee Benefits Legal Compliance. The book provides case studies in all the different areas that our firm works, but specifically right now, I'm going to be telling you about the way in which fiduciary litigation has expanded to health plans. There is a misconception among the plan sponsor community that fiduciary responsibility stops at retirement plans. That is untrue. So let me grab the, guys, I apologize, I don't have my book in front of me. But plaintiffs' attorneys have targeted Charlotte-Mecklenburg Hospital System. This was a case from 2018. They're targeting the complacent plan sponsor regardless of plan type, and they contend that employee premiums and pharmacy rebates are ERISA plan assets. Therefore, the plan sponsor is subject to group action. Ann Tyler Hall, the author of this book, our principal attorney, has said that the recent class action against health plan fiduciaries highlights the importance of establishing and documenting prudent fiduciary processes for making decisions, not only on behalf of retirement plans, but also on behalf of health and welfare plans. You have got to keep your plan participants in mind with every decision you make relative to all of your benefits plans, not just retirement plans. Okay. Forms 5500, we are currently working with a hospital group. They have hospitals in 5 states, 1,300 employees. They recently uncovered, guys, we couldn't believe it, 20 years that they had not filed the Form 5500s properly. Do you understand that if they were caught on audit, that the DOL could charge them up to $2,233 per day? And that IRS penalties can stack on top of those? And that the IRS penalty limit is a 6-figure number? I'm not going to do the math, but this is millions of dollars, folks. Millions and millions and millions of dollars. We have been working with this client, and we have effectively and proactively used our existing relationships, working relationships with the DOL and the IRS to mitigate these penalties. But just imagine if this plan sponsor had engaged counsel 20 years ago, then this situation would not have become what it is, even if they had surrounded themselves with reputable, qualified, proactive service providers in that ecosystem outside of counsel. I would imagine that this would not have happened. So again, this just highlights the importance of being proactive and working with those professionals within the employee benefits ecosystem to make sure these things are not slipping through the cracks. I probably should have said this before, but I'm not an attorney. So a lot of the minutia here on this particular slide, I would not be able to explain the nuances, for example, of the IRS VCAP program. But we had a client recently, roughly 120 employees. They had a group health plan that had employer and employee contributions to a health savings account. I'm using this example because I think it probably relates well, or is relatable, I should say, to many of you on the call. This company's group health plan originally had a minimum deductible that allowed it to qualify as an HDHP, and participants could make and receive tax-free HSA contributions. Now here's the rub. They changed their plan deductible for family coverage from cumulative to embedded. Okay, and there's a little bit of data there as to what each of those words means. Long story short, guys, they made a change to their plan, but they didn't operate the plan in accordance with the change, and the change also was not properly reflected in the plan document. And so they basically, by making this change, they lost the ability to have this high deductible health plan status, and their participants became ineligible for HSA contributions. Okay, so again, fortunate this was not caught on an audit. This client has used the IRS Voluntary Closing Agreement Program, the VCAP, and our team of attorneys here at Hall Benefits Law have been working closely with this client to mitigate, and we've got about 60% to date of these penalties abated and negotiated down. But my goodness, what if they had simply made the change the proper way? What could they have done with that $124,000 that at this point they're on the hook for? They could have invested in a full-time HR role. They could have hired a chief operating officer. They could have invested in new technology, new means of production if this is a manufacturer. Guys, these are real dollars and they can be put towards something else. So be proactive in your employee benefits legal compliance paradigm. Okay, shifting forward, we're going to move on to Robert here is going to talk a bit about voluntary benefit plan safe harbors and why they are important. Robert, take it away.
Yes, thanks. As most of you are aware, the group voluntary insurance segment of the industry is the fastest growing industry in the employee benefits space. And according to a 2019 Medical Trends and Observations report co-authored by DirectPath and Gartner, 75% of employers offer some form of a voluntary benefit. And we're finding the same in our practice, as almost all of our clients and prospects have at least one line of a voluntary benefit being offered. So it's important in our guidance to understand whether they have a group-sponsored voluntary plan and how it's funded, whether it's pre-tax or after-tax. Why? Because it could be a sign of whether they may have an ERISA plan and therefore subject to the additional reporting requirements. Case in point, if the employer has a Section 125 plan in place where the employee is paying for their voluntary coverage on a pre-tax basis, it's an ERISA plan, since contributions made by the employer, or the employee, contributions made by the employee in a Section 125 plan are plan assets. It's also important when you're structuring a voluntary benefit plan that some benefits are best set up pre-tax and others after tax to benefit the employee. So what does this all mean? Well, voluntary plans are just as important as your group medical plan to be reflected in your plan document unless you meet the safe harbors that we're going to talk about. But I also recommend to our clients, whether they have an ERISA voluntary plan or not, we suggest as a best practice for them to represent those voluntary benefits and coverage within their plan document as a good faith effort to both their participants and their beneficiaries. So let's talk about the 4 safe harbors, and they are: the first is no contributions are made by the employer. Well, that pretty much happens in most voluntary plans. The participation of the plan is completely voluntary. Again, that's pretty innocuous. That happens with most voluntary plans. And I'll skip over to the blue box. The employer receives no consideration in the form of cash or otherwise in connection with the program, other than reasonable compensation, excluding any profit for the administrative services actually rendered with the plan. Now, again, that's innocuous too, because we don't know of any of our clients that receive any kind of consideration or payment for administering a voluntary plan. But the yellow box is a key one. The sole function of the employer are, the 2 key words are, without endorsing the program, to allow the voluntary insurer to publicize the program to the employees. The employer is able to collect the premiums through payroll deductions and remit those premiums to the insurer. If the plan sponsor or employer meets all 4 of those safe harbors, it's not an ERISA plan. But what we find is where many plans fail the safe harbor provision is if the employer is actively bidding, selecting, or interacting with that voluntary carrier. It may disqualify them from the benefit of the safe harbor and therefore render that voluntary benefit plan an ERISA plan. So when we're talking to employers, very few understand the need of having proper documentation of their voluntary benefits in a plan document. And even fewer understand how these safe harbors may apply to their current plans. David, are you finding the same kinds of experiences?
Robert, our experience has actually been that lots of plan sponsors, yes, absolutely, don't understand the importance of the safe harbor rules. But in what I see come through the door on a day-to-day basis, so few plan sponsors understand the tools that are available to them. And these are tools that are made available by the agencies. One of the most important tools available to plan sponsors with multiple health and welfare plans is the WRAP plan document. And I'm just going to talk briefly about the WRAP plan document. So many of the health and welfare issues that our team takes on and tackles on behalf of our clients are issues relative to health and welfare benefits, and either the lack of a WRAP plan document or a WRAP plan document that is out of date. So this slide is going to just, again, briefly describe what a WRAP plan document does and why plan sponsors should have one in place. There are lots of efficiencies that are built in if you have a WRAP plan document. And if you do have further questions about WRAP plan documents, I urge you to speak with Robert or me after the webinar. But let's take a quick look at the slide together. So WRAP plan document contains language that covers the plan sponsor's obligations, discretionary powers, benefit limitations, and power to amend and terminate the plan. Now, this, guys, would be relative to all of the plans that are represented in the WRAP plan document. It fills the gaps where insurance coverage documents fall short. Again, because the plan wraps around all of the individual plans, it allows, this is so important, it allows for a single Form 5500 filing rather than one Form 5500 filing for each individual plan. Not only does this remove the nightmare of multiple Forms 5500 filing, it also reduces the risk by whatever number of plans you have down to one, right? So the benefits to the employer are that you get back your time and the overall cost is less, and it eliminates the potential for multiple late filing penalties when you only have one filing deadline for these plans under the WRAP plan document. So I'm going to shift over to Robert now to talk a little further about how to attain and maintain plan compliance. Robert?
Yes. Well, Select Choice Benefits wanted to take this issue, compliance, head on to assist plan sponsors as we understand the importance of the challenges that employers have with the ongoing issues related to compliance. So we're very happy to be associated with Hall Benefits Law to assist our clients with all the legal resources they need that will help them attain and maintain this compliance. In the midst of our current pandemic, I reached out to David several months ago and his firm to help develop a comprehensive checklist, if you will, to provide our clients with a clear, concise, accurate document from which to identify some potential areas of concern, including COVID-19. And as we go through it, you'll find it very thorough and inclusive of the ACA, as you really can't talk regulatory compliance without talking the Affordable Care Act.
That's right, Robert. And two, when Select Choice came to Hall Benefits Law and was asking about developing this this tool for plan sponsors, we recognized an opportunity here for a partnership, and as such, we'll describe a little later in the program some preferred pricing that we're offering for clients of Select Choice Benefits who encounter an issue or who need to have a deeper conversation with ERISA counsel. But as Robert goes through the items included in the health and welfare compliance checklist, and here is one of about 20 or so pages of the checklist, keep in mind that every one of the areas on the checklist carries penalties for noncompliance. So, in less than 2 years, Hall Benefits Law has avoided and abated over $60 million in plan sponsor penalties using this very approach. And so we don't want to keep this a secret. It's a ridiculous thought that a plan sponsor, no matter how well-meaning, can keep track of all the compliance requirements. This tool is literally meant to be a checklist. Used properly, you will uncover areas of noncompliance, and with the help of your service providers, those areas of risk will be eliminated systematically. We hope you will start to work with the checklist in partnership with someone like Robert, who can help you identify the areas in which you most need help. So if you'll just take a quick look at the list here, it's structured in such a way, and Robert will go over the 9 sections. But here, for example, under mandatory plan documentation, we can identify by using the checklist whether there are client compliance issues with the plan sponsor, and then we can make recommended next steps. So that's the way that this works. It's very simple. But Robert, I'm going to let you walk through the 9 sections of the document.
Okay, David, thank you. Now bear with me here. As David said, it's comprehensive. It has 9 sections and up to 66 subsections within the document. But I thought it was important to share all of this with you so you could see for yourself how comprehensive it is. So the first section is the mandatory plan documentation. It includes ERISA and exemptions, the wrap document, as we already talked about, the required document provisions, any amendments, the avoidance of an unintentional MIWA. Now, MIWA is a multiple employer welfare association. Typically, plan sponsors get in problems when they have a 1099 individual contract or independent contractor on their health plan, or they're going through a merger or acquisition, and they are then in a point where they are actually developing or they have a MIWA on their hands. So the document will include, and a checklist does include, of the ways that you can avoid those types of situations. And it also includes a cafeteria plan document as well under the mandatory plan documentation. The next is the required reporting disclosures and notices. It includes the IRS Form 5500, the summary annual report that goes along with the 5500, summary plan description that we talked about, summaries of material modifications. So if a plan sponsor makes any changes either to the betterment or lessen the benefit to the beneficiaries and participants, it requires a summary of material modification. The summary of benefits and coverage, many of you already know that. The insurance carriers do provide that for fully insured programs, but it really is the plan sponsor's responsibility to provide that. Mid-year changes to the SBC, any legal notices, and electronic disclosures, which are rules and how employers can use electronic media to furnish information to both the participants and their beneficiaries. The Consolidated Omnibus Budget Reconciliation Act of '85, I remember this well, COBRA. The subsections are the applicability of COBRA, does it apply to you? The plan document and SPD required, any kind of COBRA notices, qualifying event notice, and qualifying event process. The Affordable Care Act. Now, this is obviously a large piece, so it's in 2 major sections. The first section is the employer mandate threshold itself. Now, as you may know, applicable large employers have additional reporting requirements than other employers, and you need to understand if, in fact, you are an applicable large, that's having 50 or more full-time and full-time equivalents. Full-time employee coverage offers. Again, 98% of all of your eligibles need to be offered coverage, and it has to be affordable and minimum value coverage. Any kind of IRS reporting like the 1094 and 1095Cs, and then furnishing the forms to employees. The next slide continues with the ACA. It talks about grandfathered plans. Those are plans that were in existence at the time the ACA was signed into law, March 23rd of 2010. Talks about pre-existing condition exclusions, clinical trials, the prohibition of excessive waiting periods. As many of you know, you can't have a waiting period more than 90 days. You have to offer dependent coverage up to age 26, impermissible annual and lifetime limits, and out-of-pocket maximum out-of-pocket expenses. Wellness programs, preventative care, individual coverage HRAs, as well as accepted benefit HRAs and QSERAs are included in the document. Other tax rules, including cafeteria plans, health FSA contributions, dependent care FSA reimbursements, HSA eligibility and contributions, fringe benefits, non-discrimination testing, and Voluntary Employees Beneficiary Association, or VEBAs. Health Insurance Portability and Accountability Act of 1996 is a major section, or HIPAA, as you all know it. And the application of HIPAA privacy and security rules, the policy and procedures, the training required for your officers, the privacy and security officials, and any kind of business associate agreement that you need with your service providers. We also included, as I mentioned, benefits and issues related to COVID-19, the applicability of COVID-19, the Family Medical Leave Act, the COVID-19 Emergency Paid Sick Leave Act, coverage for COVID-19 testing, disclosures of new coverage of COVID-19 for high deductible health plan changes, tax-free student loan payments, which is optional, mandatory benefit plan deadline extensions because of it, and optional cafeteria plan and FSA rules. And then finally, other ERISA and group health plan rules. Service provider agreements and documentation. So if you have service providers, typically for a self-insured employer that has a TPA administering their plan, there might be contracts for the networks and the administration of their plans, service provider agreements for contract provisions, cross-plan offsetting, again, typically when you've got a fully insured or a self-insured plan administered, health care employers prohibited transactions, union employees, retiree medical, and then voluntary insurance benefit, ERISA exemptions that we talked about. But again, we talk about taking the complexity out of your benefit decisions. We understand that this is complex, and there's so much more that meets the eye than just these general explanations of each one of these areas of expertise.
That's right, and I think, Robert, you know, those of you on the call right now, Robert just took about 5 minutes to just read through basically the headings, right? And so for each of these bullet points that were just presented to you, there are compliance, requirements, there are areas of risk and exposure that we want you to be aware of. And if we get the message home to just one plan sponsor today, that you need to be more proactive in your approach to these 9 areas under the one area of your benefits plans, the health and welfare area, then we've had a successful webinar. Again, I just want to highlight the fact that Hall Benefits Law and Select Choice Benefits have chosen to partner in employing this health and welfare legal compliance checklist that Robert's and clients of his firm will receive reduced billable rates for a term of their representation by Hall Benefits Law. We're going to honor that rate. If you're registered for this webinar, whether or not you're a client of Select Choice Benefits. And then look, guys, for ad hoc issues, Robert and I are always available both to one another and to one another's clients. And I never charge for my time. Robert and I myself can connect you to other service providers within the benefits ecosystem. So I hope this isn't a call just about the checklist, although I think it's an incredibly important and effective tool in the ongoing, I guess you could call it the ongoing quest for compliance. But I hope this is also a conversation about relationships and making sure that you can have a relationship with that ecosystem where you're not being taken advantage of and people aren't doing things that they say they can do, but then they don't. Folks like Robert and Hall Benefits Law, the third-party administrators that we can introduce you to, other folks in the ecosystem, they all have our plan sponsors' best interests at heart. And that's one of the reasons I was so excited to partner with Robert today. Robert, I'm going to let you close out. And again, from Hall Benefits Law to Select Choice, thank you for the opportunity to be on the call today.
Yes, thanks, David. So as we close today, I know we shared a lot of information. And since we didn't allow for live questions in the interest of time, please engage with us. Send us in your questions and we will respond. In addition, we do have several documents that we'd like to share with you as additional resources. Hall Benefits Law has provided the top 10 employer legal risk management considerations for health and welfare plans, as well as an overview of COVID-19 legislation and guidance to health and welfare benefits. Select Choice Benefits has provided human resources role in plan compliance and suggested practices for plan document requests. Again, as David said, if you'd like to speak with either David or myself, feel free to contact us. That concludes our webinar this morning. Thank you for attending. David and I would like to pass on our appreciation and have a fantastic rest of the week.